Well, it's 10:30. Today is December 1st, 2022. We are speaking from the St. Croix County Government Center's room 1284. And this is what was published as the November meeting to be held on December 1st of the St. Croix County Zoning Board of Adjustment. I'm Buck Malick, the chair, and I'm a resident of the town of Hudson in St. Croix County. I'm going to ask the other board members to introduce themselves for the record now.
Dave Peterson, citizen member, town of Kinnickinnick.
Joe Miller, citizen member, town of Hammond.
Greg Talajon, district supervisor for District 14, Aaron Prairie, Warren, a little bit of Warren, and Richmond Township.
Dave Nickham, town of Baldwin, citizen member.
And I'm Mike Wozniak, Land Use Administrator for the county in the Community Development Department. Land Use Administrator also includes serving as the county zoning administrator.
And also in the room is Julie Peterson. She keeps our records for us and keeps us organized. Thank you. So that takes care of the call to order and the roll call. Board members, we have two sets of minutes for the meeting of October 27th and the meeting of November 10th. I'm looking for approval, but I do think the October 27th meetings minutes have a lot of extraneous material in them, and so I would suggest that whoever makes the motion to approve those minutes do so with the proviso that those extraneous comments will be removed before it becomes our permanent record.
So move.
Second.
Further discussion, anybody? All in favor of approving those minutes with that one adjustment, please now vote aye.
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 And any opposed, vote nay. That's a unanimous decision there. We have two matters for consideration today. I'm going to call on Mr. Wozniak now to make the presentation. I see there's one person in the audience. Just mentioned that if you plan to speak on either of these matters, we'll be delighted to hear from you, but only if you first sign the little piece of paper on the credenza over on the wall to my right so that we get your oath to tell the truth.
Buck,
Okay.
I will just let you know, Caitlin's a member of our staff, so she's just here to observe today.
Well, Caitlin, we don't expect you to give any testimony then. We're delighted to have you. Can you see and hear all right from where you are? Yep, perfect. Good. Well, welcome. Mr. Wozniak, it's yours.
Yes, Board of Adjustment members, Mr. Chair, the first item on your agenda is a consideration of a conditional use permit request from Jason and Catherine Skagen and the properties at 1434 Triangle Drive in town of St. Joseph, the Holton area. And I'll note their agent is Shane Hoffs of Hillside Lifts. This is a conditional use permit request to grant permission to construct a lift on their property located along the St. Croix River in the lower St. Croix Riverway Overlay District, of course. As usual, we've included a staff report and a copy of their application, and I'll note that we hadn't received any comments on this item as well as of yet. I would note that the property in question is a 2.07 acre lot, as noted on this slide, approximately 150 feet wide. The dwelling is legal non-conforming due to not meeting the top of bluff setback. The home sits about 27 feet from the top of slope, just for your interest. And the lot is also legal non-conforming because it's not meeting the current required width under the riverway of 200 feet. The lot and home meet all other requirements in the Riverway Overlay District. And what's being proposed here is a lift that would be placed about 45 feet from the south property line. And there would be limited vegetation removal or pruning to accommodate the lift. And we have included a plan spec sheet that typical of what we receive for proposed lifts, indicating what they're planning to have constructed on the property. I would, and also some additional details of the car or tram itself. Again, I'll note we haven't received, in this case, any comments from Town of St. Joe or Wisconsin DNR on this one. Our typical slide we include that has the criteria that you have to consider for consideration of a conditional use permit that's located in the Riverway Overlay District. I won't go through these because you've seen this many times, but if you have any questions, you can let me know.
While you're catching your breath there, let me just put in a question that I'm sure somebody's going to ask. One of the requirements of the DNR's Natural Resources 118 rule is that the a lift to be located in the least conspicuous location on the slope. Is that, in your opinion, present in this case?
Well, what I would say is the cover appears to be, in terms of the vegetative cover, appears to be fairly consistent along the bluff in that area. And so I can't see how moving it with the limited width of the lot, moving it in one direction or another is going to have much difference in terms of the aesthetics. That would be my take on it.
That sounds like a long way of answering yes.
Yeah.
Thank you.
I'll note in the findings of fact and conclusions of law that we've included in the staff report, I just call out one thing. Given the holiday, we had some last-minute editing, and our director, Ellen Denzer, did, and I have noticed just a numbering glitch where there's two number 7s in the findings. So we'll correct that in the if you're otherwise comfortable with the proposed findings, we'll correct that in the decision document that the chair will sign. And I'd note that this is a typical reason for a lift. The lift is required because pedestrian access to the river, because of steep, rocky, unstable, wet site conditions that would make it hazardous to negotiate otherwise. And frankly, the lift is probably less impact than constructing a set of stairs. So typically, we find it as a suitable means of for the property owners to get access to the river. And the plans would conform in terms of the car of the lift complying with the ordinance standards, applicable ordinance standard. The and again noted under number 4, as the chair called out, the lift shall be located in the most visually inconspicuous portion of the lot. I would suggest that that is the case. It probably isn't going to make a whole lot of difference if you adjusted it a little side to side from where they're proposing to locate it. They, of course, will be required to have all visible parts of the lift be painted or finished in earth tone, non-reflective colors, and shall be visually conspicuous. Their agent contractor has done a number of lifts along the St. Croix within the county and is familiar with that requirement. You'll see in terms of native vegetation plantings shall be used to form a vegetative canopy to screen the lift from the river. We are recommending later on, I'll go through this in the staff recommendation, a pre-construction meeting where staff will take a more detailed look at that. I expect that will happen in the spring, weather permitting, and if we feel any specific vegetation treatment is required, we will work that out with the applicant at that time. I'd also note that lifts allowed by CUP are allowed by CUP if they meet the standards referenced under number 7 here, and that includes really limiting the vegetation alteration removal, and only one lift may be permitted on a lot. Of course, they're only proposing one, and also that they have plans submitted by registered professional engineer or architect showing that the lift components are securely anchored to prevent them from shifting and from causing accelerated erosion. And I would note that one issue that we did have to work out with the applicant in this case is when they submitted this, their plan did not clearly show what they're intending for landings, both at the top and the bottom of the lift. And when we pressed them on that issue, they responded that they would be doing a 40 square foot landing at the top. And originally they asked, they said they wanted to do a much larger landing, actually a landing deck, if you want to consider it, at the bottom, in the range of 300 square feet. And we told them that that wasn't going to work. It would exceed the standards. It wouldn't be allowed under the rules. And so they've since come back, and the applicable standard, which actually can be found in shoreland regulations for lifts, because the riverway regulations have a standard for landings for stairs, but aren't specific on lifts. But in shoreland, there is a 50 square foot maximum. And so that's what we're applying. So you would see under the findings under number 8, it does reflect that and other applicable shoreland standards as well. And then I won't read through under number 9 under the findings everything here, but this is addressing our specific review criteria, and I would say generally we feel that this, like a lot of the other lift proposals, is consistent with the criteria we use to consider conditional use permits in the Riverway Overlay District. We do have, just remind myself our total number. We have staff recommendation is for recommendation for approval of the requested conditional use permit to construct a lift at 1434 Triangle Drive in the town of St. Joseph, subject to the 12 conditions that were spelled out in the staff report. Again, I would clarify on condition number 2, by limiting to that 50 square feet, I think the thinking with that is, if you think about a 5 by 10 or some comparable dimension, if there is a person who's disabled or something, there's a little more room to negotiate. Let's say you had a wheelchair-bound person or something like that, as opposed to, say, even a 40 square foot, 4 foot versus 5 foot width, that sort of thing. I think that's the basis of that, but in any event, they're limited to the applicable maximum standard there. And again, I would just call out number 3, we're recommending that an on-site pre-construction meeting be scheduled with staff and the extent of the area where vegetation is to be removed shall be flagged. Such area shall not exceed the 1 foot on either side of the lift route and shall not exceed 8 feet in overall width. And so that's something that I think we can better negotiate prior to when they're ready to construct. And then work with them on a revegetation plan if necessary. The rest of the conditions are largely our standard conditions we include with all of our CUPs. So I won't go through those, but can answer any questions the board may have.
More of a comment than a question. I looked over, kind of glanced over the edge. I went out there, and it's going to be a real challenge as far as erosion and vegetation. So I certainly want to stay. It looked like it was almost vertical to me going over the edge there.
Yes, I agree, and both the topographic map suggests that and the visuals suggest that. So that's why we're thinking that we'll make them stake out the alignment and what they're going to need, and talk through what they're going to need to remove, and then come up with a strategy on what they may need to be to do to avoid erosion, but also create a good vegetative cover, which in the long run will keep the erosion from happening.
Any other questions?
Yeah, scroll back to the screen that's got the elevations on it.
Well,
Right there, right
yeah.
there. Okay.
Yeah, you can see that.
Those are 2-foot contour lines, I assume?
Yeah.
And they are close together.
Yeah. Now, where's the one picture where it shows where the lift is going to go? Is it the next slide? Or, yeah, right there.
There's another view in their application
Yeah.
materials too, because
Okay.
they kind of cut it off just before the river. It doesn't run down all the way to the water.
Right, yeah. I guess my question is, it almost looks like there's a little flat land before it drops over the edge. Is that a correct assumption on my part?
Up top here,
Yeah.
yeah,
It's a little hard to tell from that.
drops, but it's not.
it's,
Steep.
you can see there's more space between the two contours here, and it's starting up in that area. And so, yes, it's not on the steepest. I mean, we've had other proposals where to limit both the visual impact from the river as well as from the applicant's home, they've actually done some stairs and stopped the lift before the top of the bluff. In this case, they're not doing that, but yeah, they do have a more modestly sloped area there.
So how's that going to affect the levelness of the platform as it drops over the edge?
Yeah, well, I've been involved with a number of these because prior to coming to work for St. Croix County, I was down on the Mississippi River in Goodhue County where there were a number of lifts done, similar kind of situation. And what often they do is they'll bring it up and then you know, they will have to, they can't really have it crest the hill and the grade of the track change, but they have to position a landing so that you can access the car part of the lift, and you know, usually it's modest adjustment of that top of the slope to accomplish that. Very modest. They really don't want to change that a whole lot because that's how you create erosion problems.
Yeah. Okay.
That's why we were asking them about the landing, because they didn't propose any landing in their drawings.
Mike, do you have any idea how many trees they might have to cut down?
We couldn't determine the timing of this. We couldn't really get down and walk it. And so, again, that's why we're depending on that pre-construction. And we can require vegetation replacement. Most of these, they're trying not to fully take out trees, but rather just place them so that they prune, at least no canopy trees, so that they just have to prune branches rather than take out the whole tree. I don't have an answer for you on that, I have to say.
Are you confident that the location of this lift is not an excuse to cut trees to open up a view to the river for the house?
Yeah, I mean, that's always a good question, and
that's really just a different way of asking Mr.
if you
Nickham's
see where
question.
it's positioned,
It doesn't seem to line up exactly.
no, it doesn't. So our view as staff is that that's not their intent. This is to gain access to the river. And if they were intending it, they'd probably have it lining up with
Picture window.
picture
Further
windows,
to the north, yeah.
any outdoor space that, you know, right behind the body of the house.
My guess is at the rate that slope drop, that other than the top 5-10 feet, I don't think there would be any.
Whatever
It
you
would
could
just be
view
the
up
first few
top,
trees, if at all.
again, from the home, if you don't want to see the top of the lift landing, they're usually not very obtrusive anyways, but if you don't want to see those, you're going to have it to one side or the other. And that's what a lot of them seem to do. They often don't run it right down the center of their lot, right behind where the house is.
Well, we favor lifts. The ordinance favors lifts. Everybody's entitled to a lift. It's just a matter of doing it in the best possible way. They increase the value of a property. They increase its utility. They introduce a safety factor. But all construction on slopes involves some risk of erosion potential during the construction phase. So I would hope that when you have your pre-construction meeting, you do your very best to assure that they don't do this just before a big storm. You know,
Right.
they'll probably use hand augers for a job like this.
Yes.
And they'll probably get it done in one day. And any tree planting that they do, they can probably get done the same day, and it should be possible to avoid a day that's immediately before an expected rainstorm.
The lifts are,
Further than, I actually have more to say on that topic, Mr.
Pardon me,
Wozniak, but
pardon me.
I hope you can recall that for the time of your meeting. But the top, as discussed, of the lift has the potential to become a kind of an erosion track. You know, people will have to walk to that landing and load their picnic baskets and whatever else, the oars and the life vests and all that. They'll be walking back and forth, and the potential for the path that they travel to become a route that collects water and then runs it right down the path that's been the path of the lift, plus the increased small amount of impervious surface that the lift, by reason of its rails and its building, its car and so on, those also have the potential to increase erosion. So I would suggest that if possible, you look hard at the area right around the top and consider whether it needs to be built up just a little bit so that it doesn't become a place that water collects and concentrates and runs down, but has the opportunity for infiltration into the ground before it gets there. I don't see that as stuff that needs to be built into our recommendation,
Right.
because you have the authority to do that as part of your adjustment of the vegetation plan.
yeah, you know, with some modest adjustment, you know, in some cases, they can steer runoff to either side of where that top of the lift is, or even we've seen some situations where somebody's done a modest rain garden just to catch the water that we'd be coming down towards where an improvement like that is. It's subtle what needs to be done to prevent that kind of problem. The other thing is we could encourage them or even require them to plant some vegetation other than, you know, a manicured lawn around the top of it, so that there'd be something that would hold back the runoff a little better. A lot of options there.
Right, and I'm sure the board would support you if when you come to having that pre-construction meeting, you get pushback. Why, we'll be happy to step
Okay.
in and impose conditions, because nobody wants erosion. But folks who are putting in a lift aren't necessarily thinking about erosion at that moment.
Right. If a problem starts, it's hard to stop, and it's a problem for us, it's a bigger problem for them.
Absolutely. We don't want their bank washing out.
Right.
Mike, wasn't the owner here this morning?
No.
They were aware of the meeting, and as was the agent, and well, they're not here.
Well, they'll have an opportunity to look at the results and to talk with you. I think nobody being here who wants to testify, I will not call for that, but I will declare the hearing closed now at 10:58, and I'll look to the board for whatever action you members feel appropriate.
I'll make a motion, we approve the proposal as presented.
Thank you, Mr. Miller. Is there a second for that
I'll
motion?
second that, yes.
Mr. Peterson seconds it. Is there discussion? No? Mr. Telejohn, you want to get on the record? A little glory? No? No, not this time? I see, only your vote. Okay, all in favor of the motion to approve the staff recommendation should now vote aye.
Aye.
Opposed, nay. The motion is unanimous to adopt the staff recommendation. Thank you, Mr. Wozniak.
Certainly.
Did you work this one up personally, or was it one of your staff?
This was Jared Wayner on our staff,
Okay.
planner that's been with us just a few months now, and Jared's doing quite a job for us. He's a very competent fellow, and we're glad to have him. And he's picking up a fair amount, not everything, but a fair amount of what's coming your way to the for Board of Adjustment items.
Well, at the risk of the news reporter who commented on what, a football kicker, a place kicker who had not missed a kick all year long and subsequently missed the next two, at the risk of that, I'm going to say that obviously our adopting Jared's recommendation is a vote of confidence.
Very good, thank you.
Let's look at the next one, shall we?
Yes.
Folks, or does anybody need a break?
The next
Nope.
one.
Go ahead.
The next one is a consideration of a conditional use permit to allow a wired communications facility in an R2 zone district. This request from Baldwin Telecom Incorporated is to place a prefabricated communications hut with an access driveway and a small parking area on an empty residential lot in the town of Warren at 917 120th Street. And I would note, as is the case with all our items that require public hearing, it was properly notified, and surrounding residents were sent notices as well. I'll mention in respect to this, actually, did I skip through the? At the end. Yeah, we reversed them. They're just trying to confuse me, I guess. I'll note that it's a 3-acre parcel. There isn't anything terribly constraining in terms of constructing on this. It's not shoreland or floodplain or anything like that. The topography is pretty flat, and existing land use is currently open space with no structures. You can see a cemetery to the north, and there's some residential to the south and some commercial at the roundabout located just a little further south off this view of the property. The applicants, again, is wanting to do a prefabricated communications hut. The hut would be 28 feet by 12 and just over 10 feet high. It would be fenced and gated for security, and a access drive and small parking lot, as I previously noted, would be constructed. This is a view of a site plan that you can see where the structure would be positioned and the driveway parking lot would be positioned on the property. And yes, I think that absolutely we can either work directly with the applicant, or you can add that to the conditions if you feel it's necessary to do so. The prefabricated structure is this smaller structure, not the larger one behind it in this photo. This is just an example of another one they had done on another site. So you can get a sense of all of what it is. They haven't indicated to us they plan to do that. They may have room to do it based on where they position this, but if they do not, they'd have to do it on a different place on the site rather than right next to it. They haven't indicated that's their need or intent, however. We haven't received any comment from the town of Warren. It seems like they've definitely had this in hand plenty of time, so it may be something we talk to the towns about just to make sure that they're engaging if they feel there's a need. Maybe they feel there's no need. They're probably working with Baldwin Telecom on a building permit for the project. And so I suspect they may be satisfied with what's happening. They just haven't conveyed that to the county. Our slide with the CUP criteria included under Chapter 15, our general zoning. I won't run through this, but if you have any question, this is the standard that for CUPs that are subject to our general zoning, as opposed to specific to, say, Riverway, which are just slightly different. Your options are to approve, deny, or table postponed if you feel more information needs to be gathered. The findings on this, we've just included information about the property and noted what the applicant has applied for, as I've already indicated. And they're not proposing any on-site well or sanitary system. We're just noting here. And we did run through the approval criteria and find that the proposed structure will be within the prescriptive standards, setbacks, and building size height requirements. Also that construction of a wired communication building, we do not believe would lower value of neighboring parcels. Project will provide high-speed internet capabilities to the surrounding area, which will increase the value. I don't know if it increases it, but it makes it maybe more functional, desirable place to live in the area if you've got better service these days, because everybody needs it. I note also that the limited size and scope of this project, staff are not believing that it would constitute a nuisance, and okay, yeah. I would suggest if the board's comfortable that that provision between the commas just be maybe deleted. I don't know. You know, the thing is, although it's a small structure, it is going to be a principal use of the property. So, but it shouldn't. It should maybe just say not an addition. It could say the addition of a principal structure if we feel that's necessary. Yeah. I think if the again if that verbiage between the commas that reads in addition to the principal structure could just be omitted, and it would read acceptably. Thank you. Right. Yeah, just in terms of staff's intent. Absolutely. I'll just share with you that we're bringing some of our other staff, now that we're fully staffed, into some of these, assisting with review of some of these projects. And Max Erickson, one of our land use technicians, worked on this request, and so, we're managing our editing and quality control is what our focus has to be. It's good to have extra horsepower, but we also have different writing styles and different levels of experience coming into play. Just in terms of other comments here, this is I kind of view this type of improvement as a necessary to serve the public. Our telecommunications infrastructure is pretty critical for many aspects of life, including business, personal, and emergency use. Really, we don't see anything with this that would be contrary to the public health, safety, or general welfare. Regarding staff recommendations on this one, we have, I'll just run through, we have 10 conditions recommended. We're recommending that the board approve this request, again, subject to these 10 conditions we've included in the staff report. Their off-street parking needs would be limited, but they have to conform with provisions in Chapter 15, which is the reason for their parking area, both to functionally serve the use when they need to get in there with equipment to serve it and to service it, and also to meet our ordinance standard. And largely, other than the issue raised about lighting, and we can work with the applicant to ensure that any site lighting or security lighting is directed downward. There is residential immediately, to the south of the site, and we had just a conversation with one of the property owners, but no comment from them. They were just asking what it was being proposed. And at that, the rest of the conditions are typically our standard conditions we include with conditional use permits. I won't read through these, but if you have any questions or concerns about any of them, let me know.
Tell me, Mike, how much of this is formality and how much is serious business?
Well, I'll be honest with you.
These companies can do it with or without our permission, can't they?
I'm not sure that's specifically true, but the question is, with something like this, if they did move ahead, if they balked at any after-the-fact permitting, would it make sense legally for us to pursue it as a violation and, cite them and end up in court over something modest? In this instance, Baldwin Telecom was a bit frustrated about the timing. They applied during our October application date, first Monday in October, and they were told, and it's clearly that it's considered at the following month's meeting, but they thought it was going to be considered at our October meeting, and so they were frustrated when they found out otherwise. And then they were frustrated when we told them that our November meeting was going to be held today because of the holiday. But we basically said, hey, that's the way it works for all applicants that applied at that October meeting date. So what I'm getting at is they were frustrated that the bureaucracy was required for this in the first place. And it might be something we look at and decide, hey, is there some level where the powers to be here, the board would be comfortable having staff be able to permit something like this, a structure of limited size of this nature, or does it really require a conditional use? I would say, if you were talking about that larger building that you saw in the photo, the example photo they used, that might have a lot more substantial impact, I would say, by all means, there should be opportunities for public input, but this is a pretty modest improvement, in my mind. And, but that's not my call to make, whether it should be subject to a CUP or not.
Yeah, I'd think, Greg, that you might think in terms of the next time the ordinance is being revised, and you might drop it into your file of proposed revisions for the next time around, that this be a land use permit item under the auspices of the staff, without the delays and costs of the board being involved, when it's such a small building and for the purpose that it is. Well, let's move along. If anybody has substantive questions about this application, ask them.
Yeah, Mike, refresh my memory on the paving requirements for something like this.
Yeah,
Or what's your proposal anyway?
yeah,
Proposes gravel, right?
yeah,
Crushed rock.
I believe it is. I'm just going to back up to their actual application submittal info and remind myself if it's clarified. I believe it is gravel, and I think the big concern, this kind of facility isn't going to have a lot of vehicular traffic in and out. The concern with unpaved is just that you don't want gravel, mud, anything tracked onto the road. If it was a more heavily used facility.
I guess my thought is I'm content with just some sort of lime rock road base rather than lawn.
Yeah,
You know, as little as I know about the fiber optics, it looks to me like this is just kind of like a telephone, those little units you see standing on the corner where they just visit occasionally to either connect or disconnect or do something, but I wouldn't envision a lot of traffic in there either. I wouldn't see any
Correct.
reason to put hard surface in there.
you know, that's one of the challenges on rural development is if you are in even in the village limits or in a city, almost exclusively everything would be paved. Whereas we tend to not be as demanding on that, but there are instances where it makes sense to manage erosion concerns, but also, you know, you're making it a compacted parking area, whether it's gravel or paved, is not really going to be pervious, but you're making it even more impervious when you pave it. So there's always that. We don't want to necessarily encourage more pavement than is needed, is my point.
And it doesn't seem like there's an indication of a high level of traffic that would justify one of those strips. I can't remember the term for them right now, but sometimes that's needed when there's apt to be a lot of dust or mud tracked out onto a major roadway. Yeah. Any other questions? Otherwise, I'm about to close the hearing. All right, I'll declare the hearing ended at 11:18. Would take no more testimony or documentary evidence. Now, the board will move forward to a decision on this proposed conditional use permit. Looks pretty uncontroversial to me, but who wants the honor and glory of making a motion?
I'll move we approve the conditional use permit as presented.
Mr. Peterson?
I'll second it.
Mr. Nickum gets the glory of the second. Any further discussion, members? No? No? All in favor, vote aye.
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 All opposed, nay. It's unanimous. So you make that little edit in the file, and if it probably doesn't show up in the decision document anyway, but I'll be ready to sign that then. When you have them.
we would clarify that the board will have a December 22nd meeting, and we're anticipating 2 items on that agenda. One of them was that other lift, well, we'll see if that comes back, but there was a project that we had a little glitch on public noticing that I mentioned with the Town of St. Joseph road improvement projects. So that'll be on, and remind me, Julie, the other one.
There's a variance in the town of Star Prairie for a cabin reconstruction.
Yeah.
Okay, it looks like the 22nd at 10:30, probably our usual awkward time. Designed to screw up Mr. Telejohn's business to the maximum extent possible.
Obviously, it didn't swing in the weight with the,
Yeah, he wasn't able to overturn the powers that be.
I notice there's other people that meet at 8:30 on Thursdays. Why can't we?
Exactly.
I'll bring that up again and again.
Maybe some are more equal than others. I think that is our business for today then.
we had no update apparently on there.
No, we didn't schedule it for a closed session with our lawyer. And I don't think there's anything, well, we can't talk about it at all because we haven't got it on the agenda. We'll do it. Yeah. You should have been on the stage. Well, there's another one leaving shortly. We should probably ask for another session with Heather at the December meeting, just to keep on top of that bit of litigation there. Otherwise then, it's 11:21. I'm going to declare our meeting ended. Thank you all for being here. We'll see you again before Christmas, so save the Merry Christmases till then. Bah, humbug.
I'll be waiting for